And we welcome you all today, and we certainly appreciate this opportunity to shine a spotlight on one of the state's premier law firms, Stinson. And Stinson has major operations in both St. Louis and Kansas City. And so Jeannie is a graduate of the University of Missouri with a biology degree, a law school experience at St. Louis University. And we are thrilled to have her shepherd this discussion today and to have this available for our MOBIO visitors in the future.
Thank you, Kelly. Yes, we are happy to be here. I'm actually joined with 4 of my partners that are in fantastic areas. We will touch on general IP assets and kind of things that you want to protect, but we really want to focus a little bit more on how, even if you're not into the protecting, a commercial product that you want to patent on or anything, how other areas of law may be touched on by IP, and kind of when should you look for that lawyer, even when it's not about just patenting or a trademark itself. So first I was going to introduce just real quickly, Kelly already kind of gave you my bio, and I've been practicing for about 20 years. A lot of those with my partner, Steve Kazmierski. He's got his Ph.D. in biology. He's in our IP prep and pros group for patents, works mostly on biotechnology, gene editing, diagnostics, that area. So he is definitely your biotech go-to. Penny Slicer is a partner of mine in Kansas City, and I would have to say she is an IP guru. It's funny, I started my career back at Senator Powers, and even back then, everybody knew who she was. She was the person you turned to when you didn't know that aspect of IP. I had a colleague, Ed Halick, that many of you probably know, raved about Penny. So it was fantastic to get to work with her. So she is the end all be all of IP, and especially in aspects of I don't have any experience in, and she would. So I'm glad she could join us. My last partner, Ben Woodard, he is actually our employment litigation. So kind of coming from a little different area, but that's a little bit why our focus changed today. We really want to show you how IP isn't just always about patents, trademarks, copyrights, and kind of how you need to look at it from other aspects. So again, our presentation is going to be about how IP touches more than just your general IP assets, but how it can touch all of your business facets. So kind of just a quick agenda. First, we want to just talk about those conventional IP assets. What are they? What do they really protect? How should you protect them and enforce those rights? When you do have a product and you want to launch that product, what are a few things you should be considering before you just jump right onto the market? And then we'll talk about, licensing of your rights and IP. What kind of things can you negotiate with? We'll move into employment issues and your IP rights and how those can be affected by IP and your employment contracts and NDAs. And lastly, we'll end with just in mergers and acquisitions. What do you do when you have IP and you're the acquiring party or you're the person being acquired? So first off, just your conventional IP assets. Patents, obviously, they protect products, methods, processes, machines. They've got to be new, useful, and non-obvious, but they'll give you protection of the product, not the use of, but the monopoly of the kind of the rights for about 20 years. One thing with patents is people think, oh, I have a patent, I'm just going to go start using my product. As we'll talk a little bit later, you have to make sure that nobody else has something that you're infringing on. So it's the right to monopolize the idea, not to use it necessarily for 20 years. Trademarks, think of, Coca-Cola, Budweiser, the names, the brands. I love my kids, even at the age of 2 and 3 years old, would see the Target bullseye and know that was the Target store. So just think of those kind of protections. As long as the mark's used, it's protected. Copyrights, you have books, songs, photographs. It's original works of authorship. Again, it's protected for life plus 70 years. And so there's, obviously there's state rights on that. The last thing, trade secrets. My favorite is the Coca-Cola formula, the Pepsi formula. So it's, formulas, processes, practices, how your business runs that you keep within your company as general knowledge. And again, most of the time people think, oh, great, another IP talk, and I'm going to hear about patents and trademarks and how I should protect those, and oh, what can I do if I want to litigate and enforce them? But here's just kind of the general of what we do with intellectual property if you actually need real old-fashioned IP advice.
Jeannie, can I interrupt and ask?
Sure.
So we've worked on biosimilars, interchangeable biosimilars, as compared to the pioneering biologic products that first came on the market. And Congress set a different timeline of I'm assuming patent protection. It was shorter, either 12 years or 15 years. We started the discussion at, I think it ended up somewhere between 8 and 12 years. How's that different from the patent you mentioned of 20 years?
The patent. So, I mean, Steve, I don't know if you have more information on this because it's more his area.
Yeah.
Go ahead.
Sorry. Yeah. So you're talking. There's a difference between patent term and which is the 20 years that Jeannie's mentioning, and FDA approval. So you get, that's like the small molecules. You can get 5 years. In the biosimilars is 12 years. So it's not exactly patent term. So it's a little bit different.
Okay. FDA.
Yeah.
Thank you.
FDA.
So, we talk about how do we protect these products and methods and everything. And so when you're first starting the research and development stage, you kind of look around and you say, okay, what's happening in my market? I might have this idea for a product, but what's commercial around us? I mean, is the space crowded? Do they have a lot of products the same? I know it's funny, when Miracle-Gro, I first started my practice, and one of our big clients was Monsanto, and you only heard about Miracle-Gro, but now you go down a Home Depot or Lowe's kind of aisle and you'll see tons of those products to keep, growing your plants long, weeds down. And so you have to start first thinking, how crowded is this space? Is there somewhere that I can kind of sneak in my product, and can I have some protection for that product? Also, am I going to have a name for it, right? Am I going to have a brand name for it? Do I need any kind of trademark or copyright type protection for what I'm going to come out with? And then even as early as the research and development stage, you need to think about, what do my employment contracts say about these IP assets? I mean, do we have NDAs in place with any of our partners and suppliers? Do my employees, as they're working for me, are they obligated to assign any rights for IP to me when they come up with a product, when they come up with a process? What trade secrets are we using every day in our business, and maybe that need to be protected or not? And then you kind of want to go more formal. So now you're saying, okay, I think I know what's commercial out there. I've seen my commercial products. I've seen competitors' products, but you might want to go and say, I probably need to do a deeper dive. It's called the patentability assessment. And that's where I say, I might want to patent it, but I want to see what's out there. So could I possibly get a patent on it? What other prior art products, or is there literature out there that maybe would keep it from being the new and non-obvious product that I think it is? So what hurdles, if I do want to try to patent this product, would I be facing? And as you start to think about that, you start to develop your product, or you start coming up with processes to do either methods of business or building something, providing a service, however your methods are. You think, should I protect it? I know there's maybe one big best way right now, but could my competitors come in and try to do it, tweak it a little bit and do it something different? So do I need to build more of a patent portfolio around this, kind of build up a whole fence or, a space around my product and protect it from as many sides as I can, so that I have kind of the good market advantage to my product. And then you also want to look at, what are my competitors launching that are similar to my products, and what do they have protected, right? I mean, do they have something that not only might block your patentability, but you might be starting to encroach on their or any rights they may have in the IP space as you try to launch your product. And if you start to build up your product, you're like, you know, I saw something pretty similar and I don't think they have protected it. So maybe they're now using some of what I could have as my IP. So do I need to start looking to either negotiate with them as a cross license or take more formal action in a litigation sense? And then once I do decide, okay, I do think one of my competitors may or may not be encroaching on my IP rights, when do I assert those IP rights? I mean, do I immediately make a phone call and say, hey, competitor A, you know, it looks like you've been stomping all over what I have, you know, in these 5 patents, or, you know, you're starting to get really close to this product that maybe you didn't notice, but it's patented under, you know, these rights. Or do you send a cease and desist? I mean, maybe you want to be a little bit more aggressive and you go full blown and say, hey, I don't like that you're trying to, you know, immediately just encroach on my rights and I need you to stop now. There's a lot of places that, you know, you maybe want to call an attorney at that time and say, what's the best advantage? I mean, maybe it's a competitor that you maybe like one of their products and would like to use one of their products, and there's an opportunity for a cross license or way that you can kind of share technology and knowledge with each other for both your benefits. I know, just not on patent rights, but a few years ago, there was a big article about, I think it was Pepsi. There was 6 of their employees had left and moved to Coke. And I guess they thought they could maybe get a leg up by bringing with them some of the Coca-Cola or the Pepsi formula. And I think to the I guess proud to be in the IP world, the Coca-Cola company not only let those people go, but I mean, they immediately did not look at the formula, sent it back to Pepsi, because there are a lot of competition where you can build off of each other's technology, but you need to respect people's rights as well too. So I mean, that was one of those, you read it and you're like, you know, Coca-Cola could have had the whole shebang on soda, or, you know, just cola rights, and they respected those rights and respected their competitor. And I think that shows a lot about how companies can build, you know, build their brand, but also have others in the market and not necessarily just take over everything. So there are ways to do it. Then, you know, letting alone other competitors. So now you say, okay, I think I've patented my stuff. I've protected it. I've built a portfolio of what my ideas are, what my employees have come up with, what they think is the best way to do it. But again, a patent gives you not the right to use necessarily. So now you might need to go out and say, okay, I have the right to patent this. I have, you know, maybe my trademark's cleared, but can I actually launch this product without infringing somebody else's patents? You know, so you have what's done is a clearance search, or a freedom to operate is another term. And that will kind of give you what's out there, what's been protected with IP all around the world. One other thing to think about is if you're launching more than, you know, just in the United States, patent rights are country specific. So if you want to sell to the UK, or you want to sell to, you know, Germany, those rights come with, you have to be protected in that space as well. So you not only want to look, am I clear to launch here? Am I, you know, clear to patent in the United States? But also, what about these other countries that I want to do business with? If you do run into a search and say you don't see a patent, because, but you see there's an application out there that's pretty close, you don't really have rights to the IP to block someone unless you have a granted patent. But these applications still are out there and they can one day become patents. So what you might want to do is have an attorney or someone monitor the applications, kind of, you know, have a set plan that maybe every 6 months, I'm going to go look at this application, see where is it in its prosecution? What is it protecting now? What's the scope of it as it stands right now? And is it a problem for me? And then if you do identify problem patents, you know, what should you do? Do you just shut down? I mean, hopefully we don't shut down. We want to keep progress going. So there is, you know, you can get an opinion of counsel that you don't infringe. And, you know, when I'm looking at this from my standpoint, it's fun because I get to look at like the patent examiner. Do I get to try to find and say, it's not novel, it's not, you know, obvious, or however, I want to, try to combat that patent. And so you can get what's called a non-infringement opinion. You can also get an invalidity opinion saying that, I don't infringe this product, or on the other hand, it's an invalid patent. And so what the opinion will do, a legal opinion, it does help that if you ever were to be litigated against, if you were found to infringe that product, it does keep damages down. So now that we've kind of gone through the general IP, kind of how you protect it, where your pitfalls may be as you're launching products. And again, that was supposed to be pretty quickly go through, because I think a lot of you guys have heard some things like that. We really wanted to look at, oh, I'm sorry, I forgot one more slide. With the American Advanced Act that came, I don't even know, 10 years ago now, they came up with some different ways besides just litigating. And we've always had the post-grant review. They also introduced inter-parties review. So these are ways that I want to challenge a patent because I may or may not be infringing. I think it might be invalid, but these are ways that I don't have to go into full litigation in the courts. I can go in front of the Patent and Trademark Office. There'll be 3 judges that are very savvy in technology, very good with patent law, and I can challenge those patents there without having to go to full-blown litigation. It's a little bit cheaper. It does allow for, ways to attack the differences between inter-parties review and post-grant review. Post-grant review immediately happens once the patent's issued. If you see it, you can file a PGR. You can challenge on all grounds, saying it's not novel, it's obvious, the patent lacks, enablement or support, or it's for patent ineligible subject matter. And that was also kind of came up as a big deal, especially in the biotech world, diagnostics, things like that they think are natural products or that just automatically happen. There's no user involvement, they're abstract ideas or mental challenges or mental ideas that they can all invalidate a patent. And so that's one way you can challenge a patent that may or may not be blocking your product launch. A second way is the IPR, the inter-parties review. This you can file, you have to wait 9 months after issuance, and you can only challenge on the grounds of it's not new or it's obvious over prior art. So there's not the enablement support standards that you can do in a PGR. And Penny will talk more about this, but there's also ways to cross-license. We talked about a competitor might have something out there that you like, and you might have something they like. And so there's a little bit of negotiation that maybe we don't litigate, we don't throw each other to the wolves in the courthouse, but we say, hey, maybe I'll give you a license for, such, limited use for this and back and forth. One more thing, I guess, before we leave the product launching is you do need to make sure that if you do have a patented product, that you have labeled it properly, right? You've put it in the public, notified the public that this is patented, this is what it covers, this is, when my patent number, so you can look it up, see when it was granted, how much longer is the patent term, and you put the public on notice. So without that, I guess I'm gonna turn to Penny. And so now we're gonna talk more about licensing our IP rights.
I did see that there was a question in the chat. I don't know, Jeannie, if you can address this, I'll read this to you. I think this may again be an FDA issue, but is there a difference in timing for biosimilar patents between US and Canada? And she says, I believe it is 12 versus 8 years. Doesn't that impact patent value creation if Canada could initiate generic versions of such products sooner?
So I guess I'll take that one again, since this is sort of my area. I'm not sure about the difference between the timing of US and Canada, and really like the question about patent value really depends on where you intend to commercialize. So if you don't intend to commercialize in Canada, for example, it would make 0 sense to file for patent protection in Canada, because like Jeannie pointed out just a second ago, patent protection is country specific. So a patent in the United States can't be enforced in Canada. Likewise, a Canadian patent can't be enforced against somebody in the United States, except if you try to import from Canada, that kind of thing. That's where it would, a US patent would create value if somebody was trying to bring an import an infringing product into the United States. So.
And then Scott Brown has a question about employment. So I'm going to hold that for Ben. Ben, you might look at that and he'll, I think he can address that issue and is already planning on addressing that issue, I think. So, okay, on the licensing front, I wanted to just highlight a couple of issues that I've seen that can be issues that you don't necessarily think of in the licensing context. So as you know, really any type of intellectual property can be licensed, meaning that the owner of the intellectual property, if it's a patent or a trademark, can give another party the right to use the patent or trademark in conjunction with their business. And there are a variety of different types of licenses that your business probably will be involved in. So there's out licensing, which is basically where you're licensing your technology to another company or your trademark to another company. This can include distributors, for example. If they're going to be doing their own advertising using your branding, you may want to have a formal license agreement in place with them to ensure that they're following your standards for branding. And licenses can be exclusive, as you know, or non-exclusive, and they can be exclusive as to a specific territory. So you could give exclusive rights in Europe to a distributor, let's say, or another party, and then exclusive rights in a different country, in China, to another party. One thing that comes up that you don't always think about in these scenarios is antitrust and competition laws. So in the US, the antitrust laws can come into play, particularly if you're sort of dividing up territories or dividing up fields of use, which is very common to do, but you just want to make sure that you are consulting with counsel when you're doing those kinds of things, not just IP counsel, but actually counsel involved in antitrust laws and in Europe, competition law. In Europe in particular, they have a little stricter competition law standards. For example, if you have exclusive distributors within the European Union that are different in the different countries, that can create some problems. On in-licensing, this is when you as a business are licensing in technology or trademarks from another party. And you commonly do that with software, for example, and other computer technology, but there could be some foundational technology that you may need, as Jeannie said, to avoid infringing, and you may need that foundational technology to then build upon and use your own technology and products, for example. Those licenses can be really important to you when you're getting ready to sell the business, for example, or get investors. And so you want to make sure that the license is something that is secure in terms of that you can keep and that you can transfer on to a purchaser. So a couple of things. A lot of times people will try to negotiate a perpetual license, meaning that the license, they'll be able to retain it forever. That can backfire. Because a lot of states indicate that under the law of various states, an agreement that has an indefinite term can be terminated by either party at will. So if you think you have a perpetual license, you may in fact have a license that can be terminated at any time. So that's something to have your radar up. If you see a perpetual license, you may want to figure out a different way to structure the agreement. Also, you need express ability to transfer the agreement upon a sale of assets, for example, without the consent of the licensor or owner. anyone looking to acquire your business will be looking to make sure they don't have to seek consent or renegotiate the license. And then lastly, there are some provisions under the Bankruptcy Act now that enable you to retain a license or opt to retain a license, even if the licensor goes bankrupt. And so you want to try to, if there's concern about that, you want to try to make sure that the agreement is framed as a technology license under this particular provision of the Bankruptcy Act. Lastly, on cross licensing, as Jeannie indicated, you can do cross licensing to try as a negotiation for infringement issues. Also, you use it a lot in joint development arrangements. So you want to make sure when you are entering into a joint development situation that you are getting a license from the other party to any background technology that they bring to the table that's being used in conjunction with the jointly developed technology. So both parties may cross-license their background technology that they use to each other for the purposes of using it with the joint technology. You may also, and this is common in those arrangements, say, okay, for the jointly developed technology, I'm going to have exclusive rights for this field of use where I do business, and the other party's going to have exclusive rights in another field of use. That's proper in many circumstances, but again, whenever you're kind of dividing up markets or dividing up territories, make sure and confer with counsel on antitrust and competition law issues. And now I'll turn it over to Ben, and he'll address the employment law issues.
All right, thanks, Penny. In looking at this presentation and looking at myself and my colleagues, you're probably wondering, one of these people doesn't fit. And that's me. I'm the one that doesn't fit. I'm the employment litigator. But I would argue that it actually does make sense to meet with me, obviously. But the intellectual property is protected from the outside by trademarks from patents. But that's only 50% of the equation. How do you protect intellectual property? How do you protect trade secrets internally? One of your biggest risks are your employees. They're also one of your biggest assets as well. And so that's where I come to play. How do you protect your intellectual property from the inside? How do you protect it with your employees and also from your employees? And we start obviously upon new hires. The first thing that I always advise clients to do is the importance of interviews. During the interview phase, before they're even hired by your company, find out whether, number one, they have a non-compete, non-solicitation, or an NDA that they must follow from a former employer, possibly a competitor of yours. And that's very important to find out during the interview phase, so you can prepare and you can set up the necessary items that you have to set up to protect yourself and also try to protect your IP. One of those things is ethical walls. If you do find out during the interview phase that they are subject to either a non-compete, non-solicitation, or here really an NDA, then setting up certain ethical walls so they can't have access to certain information, and you provide in writing that they cannot disclose certain information that they acquired from their former employer to you. And you want to make sure that you have that in writing. You do not want to be caught in a situation, this is why interviews are so important. You do not want to be caught in a situation where you're doing this retroactively, when you're doing this in hindsight. You want to do this before you get a cease and desist letter from the competitor, former employer. You want to show the dates of that you put up these ethical walls, that you instructed this new hire / new employee to not disclose anything because you knew of the risk. And that goes a long way to the extent this ever goes into litigation, and quite frankly, to prevent any litigation from occurring. Another area that you can protect your company and yourself is employee verifications. I typically recommend these to be signed right after the interview phase, along with an employment offer, an employment agreement. It can also be part of the employment agreement, where the employee verifies that they are not subject to any kind of NDA, prior NDA, or you can also include non-solicitation and a non-disclosure or non-competition agreements in there. And so you want to make sure that you paper the file enough that if something does come in down the road, you can either say, well, the employee verified that they weren't subject to this. We didn't know about this prior NDA, or we did know and we set up the right procedures, the right protections, that they are not disclosing everything. We're 100% completely above board. Along those same lines, kind of in the pre-employment / offer phase, you want to make sure that you get your assignments. It is very, very difficult, if not almost impossible, to get assignments from employees after they've left. Either you can't find them, or they're unwilling, or they want money for them to sign certain documents. We've run into this time. I've had clients run into this time and time again. So it's very important that you get assignments, IP assignments, pre-employment or right when they start employment. And you want to make sure those assignments have at least three sections. One, you want the assignment, which is the most important. Two, you want a disclosure, so that to the extent they come up with any kind of technology, to the extent that they stumble upon something, they inform their employer, you, immediately. Then third, you want a power of attorney, so that to the extent you can't get a hold of them after their employment ends and you need to act to seek patent protection, you are able to do so through a power of attorney. So those are all your pre-employment checklists that you want to go through every time that you hire somebody, especially in the R&D field. The other avenue of what I deal with, and what I deal with most of the time, is the pre-employment is more of a checklist. Once you have it down, very few issues come up that later down the road you might need an attorney, but it's usually a checklist. Where I typically come in as an attorney is when an employee leaves. One of the questions that was raised by, I think, Scott Brown was, do you want to notify your employees of their obligations under an NDA after they left? And I can tell you the easy answer to that is absolutely yes. I have a standard offboarding package that I provide my clients that basically lists out a letter to the employee, includes things like COBRA and things like that we don't need to discuss here, but it also includes a notice to the employee of their obligations under any sort of NDA, an assignment, or non-compete, non-solicitation provision. So it's not required that you do that, but it is definitely something that you want to do. You also want to make sure that as part of the employment agreement or onboarding of the employee, that they signed clauses indicating in their employment agreement that, yes, you do in fact have IP, you do in fact have trade secrets, and that they will keep those matters confidential. On the slide here, you can see that we reference uniform trade secret laws. You do not want to fall back on uniform trade secret laws. Several of my clients have had to do so in the past, and it's just not a position. It's a much more difficult position, because the law of most states that I practice in, what the law says is, if you don't have those provisions in your employment agreement that recognize the employee recognizing you have trade secrets, you have intellectual property, there is a presumption, or the burden is on you to prove that you in fact do, in order to enforce enforce your confidentiality under uniform trade secret laws. However, if you do have those clauses where the employee recognizes you have IP, the employee recognizes you have trade secrets, it makes it much easier to enforce those rights in court and prevent that subsequent disclosure to the extent you have to get that far. So that is everything I have on the employment side. I'm going to turn this now over to Steve Kazmierski, and he is going to talk about mergers and acquisitions.
So one point I should make early is that this also, the points that I'm going to make also involve funding, investor funding as well. So as I'm going through these points, think in terms of, what investors are looking at with respect to mergers and acquisitions. So all of the issues that Jeannie and Ben and Penny mentioned arise, and any problems get exposed during mergers and acquisitions and funding. So when you are looking at acquiring technology, or someone's looking at you in terms of acquiring your technology and or investing in your technology, you want to think about. So I'm going to sort of talk about this from the perspective of when you're the business that's acquiring the technology or in intellectual property that's related to that technology. And then also, what you should be thinking about when you're the party that is seeking to be acquired. So, a big exit strategy in a lot of startups is to, eventually be acquired by, a bigger player in the field. So you can do some things in anticipation of that'll make your life easier as you go through this. So, the big catchphrase with all of this is due diligence. Everybody's doing their due diligence when they're looking to invest or looking to acquire intellectual property and technology. So to start with, if your business is acquiring technology, what is specifically the technology that you're acquiring? Is it just a core technology, sort of something that you need to use to develop your product further, or is it just sort of a side technology, something you kind of need, but you don't really, it's not really like critical to, your product. So think about what is that technology that you're acquiring. Also, are you acquiring all of the technology or parts of the technology? So you don't necessarily have to acquire, all of another company's technology. You can, sort of cherry pick what you need. Then once you decide on the technology that you're acquiring, you want to take a careful look at, whether it's protected by intellectual property. So, I mean, are there patents? Are there trademarks? Are there copyrights? Is there trade secret? The trade secret one gets really tricky because trade secret and know-how go hand in hand. And so, it's not just some piece of paper that you're getting that provides you some protection, but you need, some knowledge that's, encased within somebody's, a person's brain. Think about, what IP you are acquiring. Are you acquiring just patents? Are you, getting the trademarks, the trade secrets, and the know-how from that company that you're acquiring? Think about whether the technology and the intellectual property furthers your business goals. That question about the Canada patents versus United States patents, because something's patenting and actually intellectual property is country specific. You want to think about do you need that patent that in Vietnam, or do you need that trademark that's registered in Europe? You want to make sure that it aligns with your business goals. Then once you've identified that intellectual property that you want to acquire, you think you need to acquire, look at what protection it provides. What's the timing? So, if a patent's going to expire, 6 months after you acquire that patent, do you really need that patented technology, or do you need, could you wait in terms of deciding whether you want to acquire that patent protection? Also, you want to look at the scope of what that intellectual property is. Do you have, a patent issued on some technology, or does this company that you're acquiring have narrow scope, or is it broad scope? Does it really provide you some a broad scope of protection? Also, is it just a country specific thing, or do you have global protection because you've got protection via all of the countries that you're going to seek to commercialize in? Okay, Jeannie, you want to advance? So then, continuing on with, when you're acquiring intellectual property, you want to look at whether that intellectual property is enforceable. So you look at things like, are maintenance fees paid? Is the inventorship correct? Has it been assigned? Like Ben's point about trying to get assignments after the fact. So sometimes we see acquisitions that when you dig down, you see that a patent's expired for some reason. Maybe there's a terminal disclaimer that was filed off of one case. And so something that looks on its face like it should be enforceable is not really enforceable. You want to confirm the ownership, or can you obtain ownership of those patent rights or those intellectual property rights, via assignment or whatever that company is, has. To build on Penny with respect to licensed rights. If you're acquiring rights that have been licensed, can you get those IP rights, that have been licensed through that company that you're acquiring? And then, has the company that you're acquiring done a freedom to operate analysis on their own technology, to make sure that, you aren't buying technology or intellectual property that infringes somebody else's patents or intellectual property. Okay. And then from the perspective of when you're being acquired, so now you want to look at the state of your intellectual property. Is it enforceable when somebody's looking at your company? You want to be able to present to them, something, technology or intellectual property and technology that has solid intellectual property protection. You want to cross all the I's or cross all the T's and dot all the I's. One of the things that we see a lot of requests for are an IP schedule. So just a list of what are all the patents, the patent applications, where they're filed, what's the state of that patent application. It's easier to keep a running list of what your IP schedule is than to try to build it, when it's requested, by either an investor or an acquiring party. And like Ben mentioned again, confirm ownership. Make sure you get the assignment rights transferred to you, when you're filing these applications. Don't wait until you have the problem of, an employee's left and now you have to, try to seek that protection or seek that assignment. Again, like I mentioned before, have you conducted an FTO analysis on your own technology to make sure that you aren't infringing anybody else's, intellectual property, so that when, somebody comes knocking on your door to invest or acquire, you can say, look, we've done a search. We haven't found any, problem patents or applications. We can transfer this to you free and clear. And then again, to build on Penny's point, this, transfer of licensed IP rights, make sure that you have the ability to transfer those rights that you've licensed, in your license agreements, have you, can you sub-license the technology, or is that acquiring party going to have to go seek its own license? There's a question about, during the M&A process, what type of diligence is recommended in terms of assessing enforceability of IP you're acquiring? Again, that would be, have maintenance fees been paid? What's the timing in terms of, patent term? Have these patents expired? Are they going to expire soon? Or do you have, a lot of patent term remaining? And also the freedom to operate is an important one, I think, just because you never want to guarantee to somebody that they're not going to infringe some of these patents, because something will come out of the woodwork. So, you do your best diligence. You always recommend to somebody that's acquiring or asking that question, put some onus on them to actually do searches and conduct their own searches, not just rely on what you tell them.
I would also say on that question too, it really, you kind of have to drill down as the acquiring party, what IP is really important to you, before you decide how much you want to assess enforceability, because it's, it can get expensive to try to assess how enforceable certain rights are. And so usually you'll want to look at, okay, how important is this IP to the business overall, and assess its value, and then kind of weigh that against all the different types of things you could do to assess enforceability. You know, on the, if it's worth something, but not a lot, you might just look at title and maintenance fees and those types of things. If it's really what they're paying for, if, you know, this one patent is it, then, you know, there may be a lot of additional review in terms of looking at prior art to see if it's strong from a validity standpoint. So it really depends on how important and what value the acquiring party places on the item, I think, as well.
So another question that was posted in the chat is, during the M&A process, do attorneys for both the buyer and seller / investor or acquirer have an obligation to disclose potential liability issues? What part's an open book and what part is an adjustment to the value of the deal that needs to be kept private? So maybe Penny, a lot of these deals, you know, there are warranties, you know, and that kind of thing. And so, you know, that would certainly arise, you know, in terms of, you know, dictating your obligation to disclose. I mean, it's probably one of those things that I would think that you want to disclose when there's, you know, potential for liability.
There, yeah, normally a lot of times you'll have, like in the reps and warranties, you'll have a warranty that you own all of the IP, but then there'll be exceptions to that will be listed on a schedule, which would be the exceptions that you produce during due diligence. So your obligation to disclose kind of gets tied into the reps and warranties that are being made. And certainly there's a certain level of just fair dealing as well. But normally you want to disclose the potential issues, and they're usually tied to the reps and warranties that you're giving. One issue that can get kind of tricky is, like on the infringement analysis front, you still want to maintain attorney-client privilege for information that the company has. And so oftentimes what we'll do is if the party who's being acquired has obtained opinions as to non-infringement, for example, rather than actually disclosing the opinion to the acquiring party, which could waive attorney-client privilege, they'll instead provide any prior art references that had been located, some of the underlying facts and materials, so that they can be assessed by the acquiring party individually.
Penny, I would think that attorney-client privilege declaration could get dicey in M&A of whether it's a friendly M&A or whether it's more of a purchase or takeover. That also, is that firm going to be continued on in the new? It'd be fascinating to see behind the scenes just what all goes into it. But I know that there's ethical standards that are set, professional standards, and probably court guidance on really what to follow and what pathway to follow to get the deal done.
Yeah. And there are, you know, they have these things that where you can share attorney-client privileged information under certain types of agreements. but the problem with those is sometimes they're not, it's very fact specific, and sometimes they're not enforced by certain courts. So, you know, it is an area of caution, but that only applies, just to be clear, to attorney-client communications. You know, so if the seller has obtained an opinion from me as counsel where I've given an opinion, okay, I think this is patentable, or I think this is not infringing, and here's all the reasons why, that communication is privileged, and it's really to the benefit of both parties to keep it privileged and secure for purposes as against others later. But a lot of the underlying information that counsel relied upon can be disclosed. And also a lot of times we'll have counsel talking with, you know, the purchaser's counsel, talking with the seller's counsel to help give them guidance as to things that they can look at without actually disclosing the communication itself. But it can get tricky when you're sharing information that you've really learned from your attorneys. And I would just caution everybody, even outside of the M&A context, but with investors and also with other parties outside of the company, whenever you find yourself talking about what your attorney told you, stop. Don't do that. Think about or talk with your attorney before you start conveying detailed information about those communications, because you can inadvertently be waiving a confidence or a privilege that you don't want to waive.
Speaking for a friend from a probate matter, just saying. Everybody, thank you so much for joining us today.